So watching him sort of in our limited interaction and scenes together, it was really cool to see him juggle that and how he was able to go in and out of like putting on the director hat and then being Ryle and then having to divorce himself from, seeing maybe Lily and Atlas have a bunch of chemistry and having to take himself out of being Ryle and being the director. And I was like, man, that must be such a head trip to have to be like, wait, why are they having such a nice time together?
Hi, besties. I have a brand new judge that's my favorite. I wish this judge could be in New York because this judge doesn't seem impressed with Blake Lively. And a magistrate judge in federal court in California made a decision on Blake Lively's motion to compel, the one that she did filed against all those different parties of Wayfair, the third parties that she wants them to produce documents, like Tara Hanks, the health coach that prescribed probiotics to her for her immune system after she had and been on a lot of rounds of antibiotics. Okay. So she filed this stipulated joint motion with Wayfair and she wanted them to transfer the motion to compel back to the state of New York and into federal court in New York after the judge there had already denied it and said he didn't have the jurisdiction. And if that wasn't enough, then the judge needed to compel them to turn over documents now. And this judge, magistrate, was pretty saucy here. This judge has made a decision not by having a hearing, but instead is just looking at the overall arguments on both sides. And it says Blake Lively moves to compel 8 individual respondents to comply with non-party document subpoenas served on those respondents in connection with a set of consolidated cases pending in the Southern District of New York. Compliance of those subpoenas is required within this federal district. However, because the respondents live, work, or regularly transact business here. So if they were to object to the production of any documents, Lively must by default move for an order compelling production here. So he was not going to allow her to transfer this case back to New York. He said that there's no reason for it to go back to New York because compliance is demanded and must be done in California. And then he points out that with that order in mind, that she herself told the court that there was no disputes about whether or not the subpoena was valid, what the subpoena sought, or if there were any objections to it. And she even points out that they only objected on the basis of venue in the Southern District of New York, because that is where Lively first filed the identical motion to compel filed here. So she filed one both in New York and in California, but otherwise did not raise any substantive objections or defenses to the subpoena. So as far as Lively understands, the respondents have agreed to produce all relevant non-privileged materials in response to the subpoenas. And the respondents evidently see things the same way. They advised Lively time and time again that they are presently engaged in good faith efforts to comply with subpoenas and that they anticipate completing those efforts by July 1st, 2025 at the latest. In other words, there is no ripe substantive discovery dispute between Lively and the respondents on the merits of the non-party document requests. This is my favorite part of this entire document. What Lively seeks to compel then isn't the production any category of documents that the respondents are refusing to produce. No, what Lively disproves of is how long it's been taking the respondents to actually complete their production in a timely manner, especially as to their personal devices. So Lively wants action now, or no later than 10 days from now, because she's concerned that the respondents are seeking to delay and prolong discovery. For their part, of course, the respondents maintain that any delay has been justified by the breadth of the document requests and the number of digital devices from which they potentially must be collected from. Even so, the Respondents' Council presents that productions will be done as soon as June 27th, which is tomorrow, 3 days from now. but in no event later than July 1st. As it turns out, July 1st is almost exactly 10 days from when she docketed her motion to compel on June 20th. He's so onto her. He is so onto her. He's mocking her because she wants it now or 10 days from now. Given the facts just outlined, there's no discovery dispute requiring judicial intervention, and the motion should otherwise become moot within days. As a result, her motion to compel is denied as unripe to the extent it seeks to accelerate the complete production of documents before July 1st, but it is granted to the extent it seeks to compel completion by no later than July 1st. So he's telling her that you only brought this because you want it now. You don't want it to wait. And just because you want it now, you're like stomping your feet and telling them that they're not doing it as fast as you want it, but they keep telling you that they are going to be doing it and they're not delaying things. And then he says, nothing in this order, of course, prevents the parties in the New York litigation from extending any pertinent discovery deadlines in the operative scheduling order so as to permit some rolling productions after July 1st. Nor should anything in this order be construed as foreclosing or discouraging good faith cooperation between Lively and the respondents if some rolling productions need to happen after July 1st, but before the fact discovery cutoff. If parties cannot agree in good faith, however, the deadline by which the respondents must complete their production of responsive documents is July 1st, which is when they said they would have the documents to her anyway. She just literally went to court and wasted money. And I don't know if you have any idea how much it would cost for this kind of motion to defend against. It's thousands of dollars, especially with the attorneys that are doing this case. So if they're representing, 7 different people, they have billable hours. And if they're charging $1,500 to $2,500 an hour, just going for a motion to compel could set Wayfair parties back $20,000 to $30,000 easy. So any single time you think about these silly motions that she's filing, it's that reason. Because every time she files something, Wayfair has to pay and has to spend the hours and the time to draft these documents. I'm just glad this judge saw through her and made his ruling fast and didn't buy it. Thank goodness there are some good judges. Can we transfer the case to California? Because I think Steve Kim would do a better job than Judge Lyman. So after I did a video yesterday where we talked about the Vanzan Inc. subpoena and how Jen Abel is moving to compel Vanzan Inc. to disclose and provide documentation about their company organizational structure, shareholders. Basically, what Jen's looking for is she needs to figure out, who is involved in Vanzan besides Blake and Ryan, who she believes it's a shell company for, and how that organizational structure would have any ties to Jonesworks. And she believes there's none. It's how she's proving the case that this was a sham action and that she wants all the communications between Jones and Jonesworks and that she needs a copy of the subpoena. And she also needs to see, did Jonesworks already give her that information before the subpoena, or was the subpoena used to actually give her the information? She's trying to figure out when the disclosure actually happened. And Blake Lively's team responded, which is hilarious because on the one hand, her team, who originally represented Vanzan Inc. in that sham action, lets the judge know in this case in a letter that we write to alert the court that the motion omits critical evidence or information that creates material misleading record. Specifically, Ms. Abel seeks to compel Vanzan to produce, among other things, a copy of the subpoena served by Vanzan on plaintiff Jonesworks LLC in this matter, and documents Jonesworks LLC produced in response to the subpoena. This motion admits, however, the fact that Ms. Abel and the other Wayfair parties have been in possession of the subpoena and documents produced in response to that subpoena since no later than May 16th, 2025. And on May 16th, she's produced a copy of the subpoena and all documents from Jonesworks. And then they send this Exhibit A as an attachment. Now, here's the interesting thing. There are multiple related cases in this court related to the action, right? So there's the Lively versus Wayfair action, and then there's the Jonesworks versus Wayfair action. And then there was the Wayfair versus Lively and her parties, which has been dismissed now and hasn't been amended. And they all had a protective order. But in the May 16th letter that they attached in here, it says that she is going to be filing this in this action, which is the Lively versus Wayfair and Wayfair versus Lively. It contains a reproduction of documents, so not originals, that she got in response to the Jones Works subpoena with a copy of the subpoena. And she's reproducing the documents responsive to the subpoena as she received them. For example, Jones Works documents were produced to Miss Lively without certain attachments and without the metadata contemplated in the subsequently negotiated joint stipulation on the protocol for discovery of electronically stored information and hard copy documents. While Miss Lively's forthcoming production reflects all metadata fields contemplated in the ESI stipulation, certain of the fields are not populated because the Jones Works documents lacked corresponding metadata, and certain attachments are missing because the Jones Works documents did not include them. This production is made subject to and without waiving any objections set forth in this response and objections to the requests, and this production contains documents stamped confidential. These documents may only be used in connection with the action and must not be shared except as set forth in the protective order. So she was giving them information, but she told them it could only be used in this action and cannot be shared. So if Jen Abel can see the subpoena in the Lively case, it means she can't bring it over to the Jones Works case because that's not the same action. They're two separate cases. And they can only share the confidential information under the protective orders rules. There's an issue here. I don't know if anyone's talked about it yet, but what she's telling them is she got documents from Jones Works, but that some of these documents she received didn't have any metadata on them, which is how she received them. And she should have asked for the metadata. But she's saying here that because their agreement requires them to have metadata, it's not her fault. It's just how she received them from Jones Works. And she says that the information can't be shared across actions. So it can only be used in the case between Lively and Baldoni's parties or the Baldoni versus Lively, not with Jen Abel. So even though Jen Abel has access to some of what she's received, and Ellen Garofalo acknowledges that they have received some, she says that she doesn't have a copy of the subpoena for this case, which she needs. So the subpoena could have very well been marked confidential, and it's not allowed to be shared outside of that action, it says, along with the fact that she is not acknowledging that letter states clearly that there's no communications between her and Jones Works in that. So she didn't disclose any of the emails between her and Jones Works or any of the corresponding, communication and how this all came to be, and that it was released to her, as well as there's no organizational information for Vanzan Inc. So that subpoena that they responded to, Blake did, and that dump of information didn't include any information about her company. And so what Jen is needing is to prove who's the founders of the company, who are the shareholders, what are their ties to Blake, and what, if any, ties they would have to Jen Abel. And if there are none, or if there are none with ties to Stephanie Jones, that would be grounds for a sham action, right? But something else that I thought was very critical here is that one of the issues that's been raised repeatedly by Wayfair is this idea that some of these screenshots could have been tampered with, could have been manipulated. And metadata is how you can, in court, prove that a document is authentic because it'll include timestamps and author information. So it would help them to authenticate who it is and where it came from. Without metadata, the authenticity of that document can be challenged or called into questions because it could raise concerns about possible tampering or manipulation. Metadata also provides crucial context about Documents such as the creation and modification dates, the file path, author, and revision history. So if it's missing metadata, it might not show the date that it was extracted and provided to her. So if this was from August, right? If she got this information from August, it was provided from August, or if it was provided from October, because theoretically the metadata should show that it was taken from the phone in October, not in August. If the metadata is missing, it would be difficult for Jen to be able to determine when this information was produced. Was it produced in August to Blake, or was it produced in October? And if it was given to Blake in August, that's a problem because there was no subpoena. Like I was saying, there's gaps in understanding the history and the origin of the document, which makes it difficult for them to reconstruct the events. And if there's altering or if there's removal of metadata, it could be considered spoliation of evidence. Lack of metadata can reduce the credibility. For instance, if a nurse testifies to notifying a provider at a specific time, but the EHR data, including metadata, shows that the entry was made much later, their credibility may be affected. And it's invaluable for validating evidence, revealing insights beyond the content, and ensuring compliance with regulations. Not all metadata is inherently damaging, but absence of it or manipulation can create significant issues in litigation because it will affect the credibility of the evidence. So, what she was telling them is listen, some of the information I got from her didn't have any metadata on it, which means I wasn't able to authenticate where this came from and if it hadn't been manipulated or if these were actually real. This is what I was provided. So if anything here is bad, it's because it's Jones Works' faults, not mine. And so the fact that she used evidence lacking metadata is a huge issue and something that could definitely be brought up when it comes to down the line as far as whether or not this evidence is even admissible. Because did Stephanie Jones tamper with this then? Did she change documents? Did she fabricate text messages? Did she create conversations that never existed? Did she change dates? There's already a significant suspicion by Jen Abel that this information was disclosed to Blake Lively before there was ever a subpoena, right? And so if Blake's then telling them, hey, some of this is missing metadata, but it's not my fault, it's totally Stephanie Jones' fault. What if metadata was intentionally left out because the date of the disclosure was in August and it wasn't in October? Because the way that Blake has been running her discovery in this case, they have been doing the extraction, the forensic extraction after the date of the subpoena was issued. So if they went in and they got the information, the metadata should show that the information was extracted in October or November, whenever the document production was made. It should not show that it was made in August. And so if any of the metadata were to show August, it would raise suspicions that disclosures were made prior to a subpoena, right? And if metadata is missing or altered, there could be tampering with that evidence to conceal that a disclosure was made prior to. It could also mean as simple as fabricating entire conversations. But when metadata is missing, it's very difficult for them to authenticate. And because their stipulated ESI agreement requires metadata, they will have grounds to have any evidence that doesn't have metadata be thrown out. But if Blake relied on any of the documents without metadata and she used that in court, that could really ultimately weaken her case dramatically. What I find interesting here too is that on the one hand, she's coming in and saying they should have this information, but on the other hand, the document says you can't share this outside of this action. So does Jen really have it? She might have some of it if it was shared that's not confidential, but we don't know what was confidential or not. So if a subpoena was marked confidential, Jen might not know that. Or in this case, if there is documents that are lacking metadata, that could be why Jen still cannot determine if Blake got the information before the subpoena or after the subpoena. That is so messy. And their letter doesn't address the fact that she's lacking She didn't produce any documents about her company to Wayfair. She hasn't produced any communications between her and Jones Works. She doesn't have any records about the business itself or the action. And that's what Jen Abel is seeking. So, sure, some of the stuff they have, but they don't have everything that Jen needs. But most important, that letter proves that the evidence that she received from Jones Works, some of it is tampered with or manipulated or being concealed, or it was deleted to cover something up. And that's going to be a process that Wayfair is going to have to figure out what happened. And absent actually getting Jen's phone, there's no way to know. And I think part of the reason why they wanted the information from Edgeworth was to see what dates these extractions took place. But what if, and this is just speculation, what if they deleted the metadata from the stuff that Blake had already received to cover it up? I'm not saying they did, but what if that happened? And in this case, what's happening is it's not Blake that said she did it. She's blaming that on Jones Works. So who has the incentive to cover up the data disclosure? Stephanie Jones would. So if she disclosed information in August and those documents were extracted in August and provided in August, and that was what the metadata was shown, and they somehow removed that metadata, is she trying to cover up the fact that she concealed it outside of a subpoena and that she violated a contract and a confidentiality contract? Maybe. Or is it that she tampered with it and manipulated it and changed it or altered it? This is messy. I do not envy the Wayfair attorneys in this. They have their hands full. I think just more importantly, the games that they're playing, where Blake is like, well, you have this information, but does she really? Jen might be able to see it, but she still needs it for this case. And if she can't transfer it between cases, she still needs to get it from Vanzan. Or Blake would have to give it and allow her to have it in this case, which this letter doesn't really say that. But games continue. And finally, the judge, Lyman, in the case of Lively versus the Wayfair parties and Judd Wallace, if you recall, Judd Wallace filed a motion to dismiss. And in a new order from the court, it would appear that Lyman is seriously considering dismissing Judd Wallace from this case due to lack of jurisdiction, and that the actions against Wallace in this case are at risk of being tossed. And if he is tossed from the case here, it's going to cripple her case completely. In a shocking order, he writes, Lively may submit a letter no more than 2 single-spaced pages by July 2nd, 2025, addressed solely to the argument made by Wallace in Street Relations in support of their motion to dismiss that Lively never identifies a specific co-conspirator committing any specific act that qualifies under the 302A2, an act taken while physically present in New York, that she is seeking to impute to Wallace through the conspiracy theory jurisdiction. Although the Wallace defendants argue in their opening brief that they are not subject to jurisdiction under the long arm statute, including via a theory of conspiracy jurisdiction, the specific argument quoted above is only squarely raised in reply. And then they get to respond to that with 2 single pages to Lively. So his whole argument is that he was never in New York. And under her law, or under her lawsuit, a lot of her actions take place all over the country. Sometimes in New Jersey, sometimes in California, sometimes in New York, sometimes wherever she was at the time. And people in this action lived all over the place. But she brought it in New York. She brought it in the state that she lives in. And she's claiming jurisdiction, diversity jurisdiction, meaning it encompasses parties from several different states. And if someone that's brought into the case says that they're not supposed to be there because the court that she brought it to has no jurisdiction over them, like Judd Wallace, she has to prove why he should be there. And he says, well, she didn't say that anything that happened here happened in New York. And she didn't tell the court that I talked to someone and did an action specifically directed at New York. This tells me that he's really considering this motion to dismiss and that Jed is at risk, because if Jed Wallace has been able to convince him that he's not subject to New York law, the case against him will go away completely. And so her job is going to be that she has to find someone that's in this group that they did something in New York, and then that action itself can be tied back to Wallace. That's going to be really hard for her because Baldoni and Heath, Nathan, and Abel were all in California. All of his communications related to people in California or in Texas, which was himself. But Nathan was not in New York. He didn't communicate with Lively. And he told the court all of his communications were with Nathan, who was working in California. And Wayfair, their company, is headquartered in California. He's giving her an opportunity to prove it, and then Jed gets to reply to it. But I don't think she'll be able to prove that anything happened in New York. And I think Jed's going to be dismissed. And this would obliterate her case because he is supposed to be the person that did the untraceable smear campaign, right? He's supposed to be the person that did the digital army, that did all the manipulation. If he's gone, the case falls apart. There's no retaliation. I have a sense that Judge Lyman doesn't really believe either side when it comes to this, and he's trying to find a way to get this out of his court. That's just my opinion. So what are your thoughts? Are you shocked to hear that the case against Blake might be unraveling? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, everyone.